Bonsoir à tous, chers collègues, chers professeurs, chers chercheurs, chers étudiants, distinguished guests. On behalf of the Office of the Vice President Research and Innovation, I'm honored and very delighted to welcome you all to the Jan Kerr Memorial Lecture. Lorsque nous nous réunissons pour un événement comme celui-ci, nous avons coutume d'offrir une affirmation autochtone en appui aux efforts de réconciliation. We pay respect to the Algonquin people, who are the traditional guardians of the land. We acknowledge their long-standing relationship with this territory, which remains unceded. We pay respect to all Indigenous people in this region from all nations across Canada who call Ottawa home. Nous reconnaissons les gardiennes et gardiens des savoirs traditionnels de tous âges. I'm very pleased to open this lecture designed to commemorate our late colleague Jan Kerr by welcoming distinguished thinkers from around the world to share innovative ideas and present to a large public new discoveries on important subjects of interest on current and future technological issues. All those who had the great pleasure to work with Jan know what a remarkable legacy he leaves behind. Founding member of our Center for Law, Technology and Society, Dr. Kerr joined the Faculty of Law, Common Law Section in 2000 and was named the following year the Canada Research Chair in Ethics, Law and Technology. Le numérique et le début de l'intelligence artificielle qui était déjà présent à cette époque dans certains secteurs de la société prenaient alors déjà de nouvelles tangentes. Great visionary, Jan quickly identified the need to examine the legal and ethical implications of technology years before these issues emerged as leading societal concerns as they are today. Cette conférence commémorative est organisée par le Centre de recherche en droit, technologie et société, fondé par mon collègue et professeur en commémoration, Dr. Kerr. The Centre for Law, Technology and Society is Canada's premier research group on technology, law, ethics and policy, and a global leader in advancing research and policy in an interdisciplinary setting for the benefit of Canadians and the world. It brings together 25 faculty members from the faculties of law, both civil law and common law sections, engineering, arts, and social sciences. More than 100 fellows, researchers, and students are involved in its activities. Over the past 20 years, this group has been leading global conversations on the impact of technology on society and civil liberties in efforts to shape policy for a better future in the digital context. It has been recognized as one of the top global research hubs with collaborations across the Americas, Europe, Asia, Middle East, Africa, and Oceania. A testament to the leadership of our university in the field of technology, law, policies, and ethics, the Centre hosts a record number of Canada Research Chairs and University Research Chairs and brings top global thought leaders to campus for the benefits of Canadians and of our students. Je vous souhaite une excellente conférence et sur une note plus personnelle, je suis très, très honorée d'avoir été invitée ce soir pour dire ce mot de bienvenue, d'une part par devoir de mémoire et de respect pour l'hommage en fait qu'on veut porter ce soir au Dr. Kerr, mais également, je dirais, à la vivacité, à l'excellence de recherche portée par le centre qui est piloté par notre collègue Florian Martin-Barito. I wish you a great conference, beaucoup de belles réflexions et de discussions fructueuses. Bonne soirée.
Thank you so much, Martin. So tonight, we're celebrating Dr. Jan Kerr. Jan was a mentor, a colleague, a teacher, and a friend for many of us, including to our distinguished speaker tonight, and just a great human being. So as it was mentioned, he was the Canada Research Chair in Ethics, Law, and Technology at the university and at the center. And very early on, he identified the need to examine the legal and ethical implications of technology years before these issues emerge as leading societal concerns. His career spanned a myriad of law and policy challenges, including robots and the law, AI, before it was cool to talk about AI, privacy, surveillance, security, digital rights management, algorithms, electronic contracting, human rights, and human enhancement, and and so on. As always, he brought a unique, multidisciplinary perspective, drawing on his four-way appointment in law, medicine, philosophy, and information studies, and also I would say thanks to an amazing research team composed of very diverse students and emergent researchers. Because Ian was a gifted teacher, a world-class researcher, a devoted colleague, and a generous friend and mentor. He was widely recognized as such a remarkable talent whose impact on students, faculty, and his field would be felt for decades to come. And so at the University of Ottawa, he was an external builder. He built, a leading role with our colleague Michael Geis in creating the LLM in law and technology, and to co-found the group that became the Center for Law, Technology and Society 25 years ago. And so in the policy realm, his work was quoted by the Supreme Court of Canada, by politicians in the House of Commons and the Senate, and in numerous government reports in Canada and abroad. And, his generosity, warmth, and good humor touched the lives of thousands of people. Whether National Privacy Commissioner or first-year law students, he made time for everyone, offering encouragement, insight, and a deeply held view that everyone had an opportunity and responsibility to help shape our collective digital future. And so to honor his memory, a group of colleagues with also some of his friends and his family, we decided to establish the Ian Kerr Memorial Fund to continue his remarkable legacy by supporting students, innovative programming, and cutting-edge research. And so first, the lecture tonight, but also a new program that is called the Kerr Fellowship has been created thanks to this fund. And I would like to thank all of the donors since Ian passing in 2019 who have contributed to the Kerr Fund. And I invite everybody tonight who liked him and want to support those kind of endeavors to also contribute to the fund. You have small cards on the table and on the screen. And so Ian's vision was to ensure that top students from around the world would have the necessary funding and support to pursue their scholarly dreams, researching legal, ethical, and policy questions, running law and tech at Ottawa. And to continue his efforts, we created the Kerr Fellowship, so to support someone from non-traditional background or someone from abroad that is not supported by the usual funding scheme that exists in Canada to do graduate studies, to come to Ottawa to study in law and tech as part of our LLM. And tonight, I don't know where she is, we have our second fellow, Gabriela, is somewhere in the room. Where is she? Oh, here, Gabriela. I invite you to so Gabriela Bolaños Weinstein, who come from Peru, is our Kerr Fellow this year. And so I will invite you to go chat with her about her research during the reception afterwards. And so the Kerr Fund also support the initiatives such as tonight, Kerr lecture, a new high-level event series to enable distinguished thinkers from around the world to share with the general public the result of original research study on important subject of interest on current and future, technological issues. And so in a time where people and leaders are starting to finally acknowledge issues regarding privacy, AI, and surveillance, I would like to note that Ian was already writing about this 30 years ago. And our world and our policies would be quite different today if people had listened, especially in Canada. It was not the only one. Tonight, I'm delighted to, welcome to deliver the Ian Kerr Memorial Lecture, a dear friend of Ian that also have been writing for a few decades about those issues, and maybe south of the border, more people should have listened to her. So a dear friend of Ian, Professor Anita Allen, the Henry R. Silverman Professor of Law and Professor of Philosophy at the University of Pennsylvania. A graduate of Harvard Law with a PhD from the University of Michigan, Professor Allen is a globally renowned expert on the philosophy and law of privacy. She received numerous honors, including the Lifetime Achievement Award of EPIC, the Berkeley Center for Law and Technology Privacy Award, the Philip Quinn Prize for Service to Philosophy and Philosophers, and the Hastings Center Bioethics Founders Awards. She's a member of the National Academy of Medicine, of the American Academy of Arts and Science, and of the American Philosophical Society. And under President Obama, she served as a member of the National Commission for the Study of Bioethical issues. She wrote many books, textbooks, scholarly articles, and has contributed to like newspaper, magazine, podcast, and blog, and appeared all over the world to discuss research. So I'm very delighted to welcome back to Ottawa because a few years ago she delivered the J. Martin Memorial Lecture on Privacy at the University of Ottawa. So I'm delighted to have you back tonight, Anita. Thank you again for joining us, and I will give the floor to you. Thank you so much.
Thank you for the introduction. Thank you for inviting me back. Thank you for being who you are. I appreciate so much being here. My husband and I actually drove all the way from Philadelphia here, and when we got here yesterday afternoon, about 1:30, our first stop was not the hotel, but the Museum of History, and we enjoyed so much seeing the First Nations totem poles and other artifacts and art of First Nations people. So it's a great honor to be here and such a pleasure to be able to benefit and be enriched by what Canada has to offer. So we are in really difficult times in the United States, and you know this, you know this so well. And so I come to you at a time when I am very troubled and worried, and my remarks today are going to reflect some of that sense of trouble and worry, and I hope it will help you to better understand what we're facing in the United States. And I am going to be speaking today very much as an American, talking about American law. But not only will I be speaking today as an American, but I'll be speaking as an African American. I am the great-great-great-granddaughter of enslaved Africans. This is my heritage. My family still lives in, most of them still live in Georgia, a few miles from the plantations on which my ancestors were enslaved. And so it's very real to me. And I also was born during the great African-American civil rights movement in the United States and grew up in the shadow of all these efforts to promote black civil rights and to achieve black civil rights, and was a confused young woman trying to figure out what can I be and become in a world where I'm not allowed to go to the same stores or swimming pools or bowling alleys or restaurants or schools as white people. What's going to become of me? So this is the history that I bring to you, the person I bring to you today, and I'm going to speak from that point of view. There are other points of view I could speak from, but I think I'll speak from that point of view today. And it's partly because in the year 2020, I came back to my usual role as law professor from a 7-year stint as vice provost for faculty. You understand such roles very well. Vice provost for faculty. And during that time, I wasn't doing very much scholarship. I wasn't doing very much teaching. And so I kind of lost track of what was happening in my own field of privacy law and philosophy. So when I got back to the university after my 7 years, I discovered that in that period of time, suddenly privacy and the right to privacy were being described as a civil right. I never heard that before. Never during the 1960s when I was in high school, 1970s when I was in college, never in law school in the 1980s. Never had I ever heard anyone say that privacy or the right to privacy was a civil right. And so I became interested in the question, how did privacy become a civil right? Okay, and I must say I felt even a little bit annoyed that privacy would be grouped with rights like the right to vote, the right to education, the right to access to public accommodations, because I think privacy is incredibly important. If you've read even one thing I've ever written, you know how important I think privacy is. But it seemed to me to be almost an affront to the African American civil rights movement for all these people to be saying, oh, privacy is a civil right suddenly. So when I say, is privacy really a civil right? I have to put that really in italics or red, because I raised this question skeptically. And when I first decided to work on this project, I saw myself as, in a way, challenging my friends, because the people who were saying that privacy is a civil right are all my allies and my friends. They're not the enemies, they're the friends who were saying it. But I was raising this voice of skepticism about whether it really is appropriate and makes sense to describe privacy as a civil right. But I must say, since I began this project a year and a half ago, which was finally, by the way, published just a few days ago in the Berkeley Technology Law Journal, the paper, 70 pages, 300 footnotes. It's a big article. But I mean, during the course of that project, the world began to change again. And suddenly I thought, oh my God, privacy better be a civil right, or we're in trouble, right? So let me just, I'm going to fill in the story today, which is going to be the focus of my lecture. But I just want to give you that background as to why this topic, why privacy and why civil rights. I understanding that, of course, you know, in Canada, you don't have the same kind of civil rights discourse that you have in the United States. Okay, but let me just also repeat my admiration for Ian Kerr. He was a friend, and he was one of the most creative, funny, innovative scholars you could imagine. And he emboldened us, the rest of us, to be forward-thinking and creative and imaginative in our approach to how we think about digital society, digital economy, digital life. And I must say that when I was here, maybe not the last time, but the time before last, I think it was in connection with the Identity Trail project, I actually gave my talk in the voice of a Barbie doll. This is what Ian inspired one to do. Barbie talking to Midge, wondering about what the internet meant for plastic people. You know, Barbie and Midge. And you know, I think, did I really do that? Yes, I did. Thank you, Ian, who freed me up to let my mind fly in that way. Well, maybe I'm not going to be quite that imaginative today. I'm not going to speak in the voice of Barbie, but I do just want to once again say, when I was asked to give the Ian Kerr Memorial Lecture, I didn't even hesitate to say, yes, of course I would come, of course I would do this, of course I would help to remember Ian. So, okay. So we are about 60 years past the beginning of the great African American civil rights movement. And as the slide indicates, there were many, many issues that this movement was all about. It was about access to the same public schools as white people. It was about being able to get jobs equal to white people, about access to voting and public accommodations. It's a wide sweeping movement. And we're now 60 years past that. And so a lot of people have even begun to, I would say, forget about the civil rights movement, to forget about the problems that caused the movement to happen. And I think a lot of people, a lot of my students, I know my students in the US, don't know anything about the civil rights movement. It's not part of their experience. And it's part of mine, but it's not part of theirs. So this is where we are. And so for all of you who don't know American law or history very well, I'll just say something which is brief but relevant, which is that in 1964, President Lyndon Johnson signed an amazing comprehensive law called the Civil Rights Act of 1964 that basically swept away couple of hundred years of African American inequality and oppression, ushering in a new world in which black people could hope to live on par with white people. And what it meant for me immediately was that whereas when I was a little girl, might expect to live my life as a housemaid. If I was really lucky, I might be a teacher or a nurse. But my parents were both high school dropouts and completely uneducated. And so my prospects were not all that bright, shall we say. But then suddenly, the Civil Rights Act happened, and affirmative action happened, and suddenly I'm being told, oh, you can go to Harvard. So you don't have to be a maid, you can go to Harvard. Nothing wrong with being a maid, but I mean, just that quickly, overnight, my prospects changed. So this is where we are, and have been. But then, as I said before, in the short period of time between 2013, when I became vice provost, and 2020, when I stopped, a new movement emerged, and I call it the privacy and civil rights movement. I should say we call it, because I'm actually on this project with one of my postdocs, whose name is Christopher Muhawe from Uganda. He's actually a Rwandan refugee to Uganda, but he was raised mostly in Uganda after spending several years in a refugee camp. He then was able to go to regular school, and he had a very successful career as a lawyer in Uganda before coming to the US for graduate study. So he and I are on this project together, I should say we. So we are working on this project, and we note the emergence of this, what we call the privacy and civil rights movement. And it's linking privacy and civil rights. And there are three different claims that are being made. And sometimes people make the claims without distinguishing them, and sometimes they are very clear about distinguishing them. But the three claims are that, one, privacy is a civil right, or the right to privacy is a civil right. Two, and three are that privacy rights and civil rights have a kind of a mutually protective relationship. Privacy protects civil rights, and civil rights protect privacy. And the movement we're referring to is a trend of asserting that all three of these things, or one or two of them, are true. Right? That this is the movement. It's a very pervasive movement that's being promoted by some of the most prominent academics, other thought leaders from the civil society sector, and even from members of our Congress. But before I say more about the who behind the trend, I should note the discourse of civil rights, because again, I know that for some people who come from other countries, civil rights discourse doesn't have the same sort of place in jurisprudence and legal thinking that it has in the United States. So many of you are familiar with the idea of natural rights, that's sort of the idea that there are these sort of rights inherent in rational, free beings that we all have by virtue of being human beings, and then human rights, which are similar to natural rights, except that we think of human rights as the rights which are also recognized in our treaties and our international documents. They're documented in a certain way, but they're aspirational. They're not positive law. But then we have our positive law rights, our constitutional rights, charter rights, fundamental rights, basic rights, thinking about Germany and so forth, common law rights. And then in the US, we have this other category of rights called our civil rights. And civil rights is not an American invention, but what we do with it in the United States is what I want to focus on today. And in the United States, we think about civil rights as rights that we have within the jurisdiction of the United States, within that territory, that are created by our government and enforced by our government, that enable us to be effective as citizens. And these rights are very important, but they're enshrined in law. And they're enshrined in law mostly through acts of Congress, or other positive law enactment. They're not constitutional rights. They're enacted by Congress. Congress has to do something to create civil rights. When I spoke earlier about the Civil Rights Act of 1964, that was a law that the Congress, the House of Representatives and the Senate, agreed upon to pass. They drafted it, they debated it, they argued it. They then sent it to the president for the president's signature, and Lyndon Johnson signed that law. And Lyndon Johnson wasn't the most liberal-minded person. He was a Southerner, and many people thought, oh, a Southern president's never going to sign a civil rights law, but he did, and the rest is history. So think about civil rights as a kind of positive right, but it's not based on a constitution, or it's not embedded in the common law. It's a creature of statute, a creature of legislation. Right? This is what civil rights are. But they're not less important than constitutional rights. They just have a very, very, very different source. And because they are based in Congress, they are subject to change. If Congress changes its mind tomorrow, they're gone, right? So we have to hope that Congress doesn't change its mind tomorrow. But the fear that I think we're living with right now in the US is that Congress could change its mind tomorrow. The President of the United States could pretty much force his people in Congress to change their mind tomorrow. And then where will we be? But we'll wait for that question a little bit later. Okay, so why this privacy and civil rights movement, and why now? And the answer, I think, to that question is tech-related vulnerability. Tech-related vulnerability is why it wasn't until 10 years ago that people began to talk about privacy as a civil right, and it wasn't until 5 years ago that lots of people began to talk about privacy as a civil right. Some of you have read the influential work of Scott Skinner Thompson, and Scott has, this is my favorite quote from Scott, "Those in the most precarious social positions are disproportionately vulnerable to privacy violations." Absolutely correct. And I would argue, as I did in an article called "Dismantling the Black Opticon" that was in the Yale Law Review Forum just a couple of years ago, that black peoples are characteristically vulnerable to 3 sets of vulnerabilities. And what I call the black opticon is this set of vulnerabilities. And I call them discriminatory over-surveillance, discriminatory exclusion and invisibility, and discriminatory predation. And in my paper, I have a much cuter way to describe them. I call them the panoptic threat, which is the over-surveillance, the banoptic threat, which is the exclusion and invisibility, and I stole that concept from a European scholar that some of you may know about. And then the final category is the conoptic threat, which is this like con job scams run on vulnerable people. Blacks in our country, blacks, Hispanics especially, and Asian Americans are vulnerable to these kinds of scams. So this is the problem of discrimination that people of color are facing in the United States, and I think that this is among the reasons why this privacy is a civil rights, or privacy as a civil right movement kind of got launched, because in the midst of all this digital economy change, and in the midst of growing AI threats, many advocates for people of color began to think, how can we find a discourse, a language, a vocabulary for complaining about and then doing something about the threats of the privacy threats that people of color, other vulnerable people are facing? Well, how about civil rights? How about civil rights? So I think that's the why, how this all got started as a way to deal with the specific vulnerabilities that technology poses for vulnerable people. And I'm speaking especially today about vulnerable people of color, and especially about, within that group, African Americans. Of course, over-surveillance, exclusion, and predation are not the only problems that people of color are facing. I think that you can also talk about manipulation, right? We know about some of the ways in which the elections have been manipulated using technology in ways that cause people to be confused about their ability to vote, or who to vote for, and what the issues facing them actually are. So I could maybe add to my Black Opticon piece a whole discussion about manipulation of people's thinking and their voting rights, political rights. And then some people think of AI as not being neatly within my triadic way of thinking about about discrimination in African Americans because AI, they think, is different from all the things that I just mentioned. So some people would include AI in a different category, but I think of AI as basically a methodology through which over-surveillance can take place, through which exclusion and visibility can take place, through which discriminatory predation can take place. So I think AI is implicit in my Black Opticon model of vulnerability. So, historical look back. If you go back in time and look at the status of African Americans, you can see that we never had privacy. I mean, so going back to the beginning, you know, we were brought to North America as most of us as enslaved people. And slaves don't have privacy, right? They don't have the privacy of a home because their living quarters are under the surveillance and control of their owners. They don't have privacy of marriage or sexuality because who they can partner with is determined by somebody else. They don't have the ability to control their own bodies. They have to have sex with whomever the master tells them to have sex with. They don't have privacy of their children and their children's lives, because the children belong not to them, but to the owner, to the master. They are put before the public in slave auctions, sold in a public forum where they have to strip naked perhaps, or have their mouths examined, or their breasts examined, their genitalia examined. Slaves were used in medical research on gynecological problems and other issues, including research that was designed to show that black people lack the intelligence of white people. So there's no privacy of any sort, informational, decisional, physical, proprietary. There's no privacy at all implicit in the life of an enslaved person. And you know, some of that same disability applied to white women, you know, in the United States in the 19th century, not just to black people. The lack of rights of any sort, pretty much, was enforced in the United States not only through law, but through terror. So that even when the law might provide some modicum of protection for a black person, oftentimes the vigilantes would say, we have to lynch that person, right? We have to terrorize that person and that person's community to make sure that they stay in their place. There was an amazing effort after the Civil War. Thank God the Civil War happened. It was a horrible thing, but it needed to happen. It happened, and after that, Congress passed laws that they called civil rights laws. That discourse was part of for the first time, part of national thinking. Civil rights laws were passed after the Civil War, and guess what happened to them? They were struck down by the Supreme Court as being unconstitutional. You can't tell private people to not discriminate. Our Supreme Court held that in a couple of different sets of cases, one called the civil rights cases, the one called the slaughterhouse cases. But these cases basically establish that the federal power that comes to the federal government through, say, the 13th Amendment freeing the slaves, or the 14th Amendment creating equal rights, that those don't apply to private people. So if a private business person wants to say to a black person, you can't come into my store, and I'm not going to hire any black people or any brown people, there's nothing the federal government can do about that. So we got these amazing civil rights laws. They were on the books for maybe a few years, but then they were struck down by the Supreme Court, and the Supreme Court then also upheld specific, we call them Jim Crow laws which allowed the southern states, or any state that wanted to discriminate on the basis of race, as long as they had so-called equal facilities for blacks, the separate but equal doctrine. So, you know, you don't have to let black people ride on the same train car as white people, as long as there's a black car where the black people can ride. You don't have to let black children go to the same schools as white children, as long as you have a school that black children can go to. And I'm telling you that up until the 1960s, I mean, my older sister went to a Jim Crow elementary school for a while, and a Jim Crow high school for a while. And I myself went to a Jim Crow kindergarten, a school that was just only for black children. I wasn't allowed to go to the same school as the white kids in my community attended. So this is where we were. With an attempt to have civil rights laws protecting race in the 19th century, struck down by the Supreme Court. And then what happened? So we have the beginning of privacy law in the US in the Gilded Age. Warren and Brandeis, famous Boston lawyers, they argue for a common law right to privacy. It sounds very lovely, protects the sacred precincts of family and domestic life, protects the home, the modesty of women, blah, blah, blah. But they didn't give a hoot about the genocide of Native Americans going on all around them and all the privacy implications of genocide, or about the striking down of civil rights laws by the Supreme Court, and they were not the least bit concerned about what are the privacy problems that Americans beyond the Boston Brahmin class are experiencing. They had nothing to say about that. So you have this right to privacy emerging, and it's certainly not being characterized as a civil right. It's a right of rich people in Boston, pretty much. Okay. One could make some linkages conceptually between privacy and civil rights. But what I'm trying to say with this part of my talk and this slide is that wasn't done. That wasn't being done. It wasn't done in the early 19th century. It wasn't done after the Civil War. It wasn't done in the beginning of the 20th century when we had the Warren and Brandeis tort being developed through the common law. It just wasn't being done. And the first time that I think Americans thought that privacy might be a civil right was actually after World War II, with the UN Declaration, which establishes that privacy is a human right. Okay, so human right. Again, not quite civil right, but human right. It wasn't until the 1960s with the International Covenant that we have privacy rights being explicitly, in the international human rights context, being described as a civil and political right. And that was a huge innovation. But that idea never had any uptake in the United States. We still don't, in the United States, much talk about human rights and incorporate that idea in the way we create law and enforce law. It's almost not a thing in the U.S. Jurisprudential context. Okay, so with that historical look back in mind, again, and I would say suddenly, because it seems sudden to me, suddenly in the 2000s, especially after 2014, academics and civil society thought leaders began to talk about privacy is a civil right. Privacy protects civil rights protect privacy. And some of the leading thinkers in this movement are Alvaro Bedoya, Danielle Citron, Marianne Franks, Tiffany Lee, Rebecca Chow and her colleagues, and then various organizations like the Legal Defense Fund, Free Press America, Lawyers Committee, Brookings Institute. But this burst of literature comes out about privacy as a civil rights. Let's center civil rights in the discourse around what's wrong with AI, what we need by way of privacy laws in the United States. And I think that it's not an accident that in the middle of that screen is a Peruvian American. Where's our Peruvian? Peruvian American, Alvaro Bedoya, who in 2000 gave a very important speech in which he announced flat out privacy is a civil right. And he was basing that claim in part upon reflections about the struggles of Martin Luther King, who was surveilled by the government, and Cesar Chavez, who was surveilled by the government, and the ways in which the informational privacy of civil rights leaders and activists in the United States their informational privacy was invaded by the government, and that their experiences kind of helped to show us why we need to understand privacy as a civil right. Not just a civil liberty, but a civil right. Danielle Citron has done as much as anybody to promote the idea of privacy as a civil right. She talked about it in her 2014 book. She talked about it in her 2023 book. She characterizes intimate privacy in particular as a civil right. And Tiffany Lee, the woman on the far left, is a younger scholar who wrote a very helpful article in which she took those three ideas: privacy as a civil right, privacy protects civil rights, et cetera, and she tries to put them into a context and explain, as much similar to the way I'm doing, explain where these ideas came from. But she is not doing so from the skeptical point of view that I am, but it was a very important and useful bit of legal analysis. So these are some of the people who have promoted the movement. And as you can see from what I'm saying, a number of the people who have been the biggest defenders of the idea of privacy as a civil right have been people of color. Asian Americans, Latino Americans, Peruvian Americans, Chinese Americans, Korean Americans. I mean, we are the ones who have been very, especially vocal in this movement. But I wouldn't say that the movement is primarily a product of people of color, because I think that if you start adding up the people who are behind this, it looks like there's quite a few people who are not people of color who are also saying the same thing on behalf of the people of color community, but also on behalf of all of us. So, these are the thought leaders, and I think it's important to give them the credit. And they are my friends, as I say before. They are my friends. Alvaro Bedoya was actually appointed to the Federal Trade Commission. So the Federal Trade Commission is a federal agency in Washington, D.C., responsible for enforcing our laws of fair competition. And it took on an important role in privacy law enforcement in the late 1990s and especially in the early 2000s. And he was made a commissioner a few years ago of the FTC, an amazing accomplishment, talking about sort of immigrants made good kind of a story, but he's an amazing person, and he had this major role on this commission. Well, guess what? Trump fired him. So this progressive voice for privacy as a civil right was there and then not there. I think he's been outspoken about the injustice behind his firing from the FTC. Okay, so, but not only did all these scholars and civil society people and so forth advance the idea of privacy as a civil right, but after 2000, lawmakers began to buy in. So you want the thought leaders in academia and so forth to be out there, but ultimately to get law made, you need to have the lawmakers, the Congress people, the representatives, the Congress people, the president, the lawmakers need to get on board. And that began to happen after 2000. It was amazing. DC Attorney General got on board. California and 19 other states began to enact state-level consumer protection laws that had some anti-discrimination provisions in them. Congress saw a flurry of bills that included some civil rights protections, Data Protection Act, American Data Protection and Privacy Act, Algorithmic Accountability Act, American Privacy Rights Act of 1924, and on and on. There was at least 6 or 7 major bills that came through Congress after 2020. And then President Biden issued an executive order on safe, secure, and trustworthy AI that was very much explicitly there to address, among other things, the civil rights concerns that accompany the use and application of AI. So I would say up until a year or so ago, it looked like, oh my God, there's this sudden but amazing civil rights movement. It seems to be taking hold. And so let's see where it's going to go. And when I started writing this paper with Christopher, we thought, okay, let's see where it's going to go. There's complications there, but let's see where it's going to go. I was skeptical, but again, it was a hopeful skepticism, you might sort of say. And my skepticism can be kind of summarized by this sentence from the paper, which is that advocacy for privacy as a civil rights framework must contend with the fact that little direct support for the idea for conceptualizing privacy as a civil right or data protection as a civil right can be found in the complex history of U.S. civil rights law. So that there's not much support for it. Doesn't mean we shouldn't adopt it, but I think that it should not be taken for granted. Because I felt like some people thought it was natural to talk about privacy as a civil right. Some people assumed that we'd always talked about privacy as a civil right. So when my students heard this idea, they didn't realize that it was a novel concept. They thought, well, this is probably the way it's always been thought about. Answer, no. This is a new thing, and we have to understand why and what the complications are. So, complications and counter arguments. One complication I've already mentioned, which is that you have this human rights framework for thinking about privacy as a civil right, but it's never had much traction in US law. That's one thing. Second thing is that civil rights leaders did not push for privacy as a civil right. Even Martin Luther King, who was unfairly surveilled by the FBI, didn't say, hey, my civil rights are being violated by the FBI. That idea never was part of his thinking about what was wrong with what was happening to him. Thurgood Marshall was the first black Supreme Court justice in the United States. And before he was a Supreme Court justice, he was one of the leaders of the NAACP and the NAACP Legal Defense Fund. And he actually opposed the litigation that led to a famous decision called NAACP versus Alabama, in which the Supreme Court, this is in 1959, the Supreme Court struck down Alabama's efforts to require that the NAACP give the government its membership list. Alabama wanted to terrorize the NAACP membership, largely black, also white, also substantially Jewish, terrorize that membership by getting their names, and then if they continue to support civil rights activism in the South, they might find that their car was, I mean, this is not, I'm not just being like paranoid about this, but it was literally the case that if people in Alabama knew that you were an advocate of civil rights, that you belonged to the NAACP, you would lose if you're a black person, you'd lose your job as a maid or whatever, driver, you would lose your job. If you were a white person, you might be terrorized and frightened back to New York, but you might be lynched, you might have your house burned down. These things happened a lot in the South. I mean, you all know the stories of the little girls who were burned to death in the church. I mean, so it was a terrible place and a terrible time. Well, Thurgood Marshall, he didn't see that this privacy issue was connected to civil rights, and he actually opposed the decision. He said we should be more cooperative with the courts. He had won the Brown versus Ward decision, and he felt like, oh, I've mastered the courts now. Let's rely upon the courts. Let's not aggravate the courts. And so he didn't want to appear to be flouting what the courts of Alabama were holding. So anyway, just second point, that it wasn't even obvious to civil rights leaders that privacy had some essential connection to civil rights. Complication. And then there were people like Hannah Arendt, intellectuals who believed that actually privacy countermands civil rights. And Hannah Arendt was this amazing political theorist. I have often cited her work. I used to cite it a lot more than I do now. But Hannah Arendt had this view that it was wrong for the federal government in the United States to use its power to compel the southern states to integrate their schools. It was wrong. That public schools, even though publicly funded, could be all white, and that if white parents didn't want their children to attend the same schools as black children, that's okay, because the school is an extension of the family, and if the family, prefers segregation, that integration should not be imposed upon them, and that black people who wanted their children to attend the same schools as white people were kind of like, people who couldn't get into country clubs. It's sort of that kind of a thing where, oh, they just want to be with the white, But it was, of course, that's not the way black people saw it at all. It was about, well, we pay taxes too. We have the same rights too. We deserve the same education. We're human beings too. There's nothing wrong with us. Our children are as good as your children. So in any event, she wrote this famous article, Reflections on Little Rock, in which she condemned the federal government for stepping in Little Rock, Arkansas, to compel white children to to compel that white children and black children attend the same schools. And she even attacked black mothers. Like, what mother would put their child in the line of fire like this? You know, I'm thinking, okay, my mother. I mean, you know, so that she didn't understand that for people like my parents, you know, who are the great-great-grandchildren of enslaved Africans, it was worth the battle. It was worth having your children face the hardship of being the first black kid in their class in order to push the anti-segregation, the racist anti-segregation agenda, to push against that. And to push in favor of equal rights. So I myself, you know, I went to a Jim Crow kindergarten, but when it was time to go to middle school, my father, who was a great believer in integration, we lived in this little town where there was a black school and a white school, and my father took me to the white school and just said, "Here she is," you know. There I was like, okay, but you know, so. I think that Hannah Arendt didn't understand that black people are not social climbers when they want their kids to attend the same schools that white kids attend. And it is very much worth having the whole family take on the burdens of integration in order to get rid of a deeply morally troubling and unjust regime of apartheid. And then finally, I would point to Alan Weston. Alan Weston wrote one of the first, he was a sociologist, wrote one of the first books about privacy and the law. Brilliant book, very influential book in the United States, probably in Canada as well. Weston's book Privacy, on privacy, and he argues though that actually if you have civil rights, they have to be enforced. And if you enforce civil rights, it means that more data has to go to the government about people of color. And that's a certain sort of risk in that. So that you get the gift of civil rights comes with the burden of less privacy. And that's also kind of like a little bit complication, thinking that privacy is a civil right. It has a relationship with civil rights that's a bit more complicated than just that we should always promote privacy in the interest of civil rights. There can be some conflicts there. So this is some of the things that we developed in the paper. And then finally, I would note that there have been efforts to legislate privacy in this civil rights framework. And I mentioned earlier that, you know, California and 19 other states had enacted privacy consumer protection laws recently. I've analyzed some of these laws very carefully, especially the Virginia law. Everybody's analyzed the California law to death. They have what I would say are weak anti-discrimination provisions. And then, actually, what makes a strong one though? So I would argue, and I do in my Dismantling the Black Opticon paper, argue that the kind of laws we need are laws that don't just say it's wrong to discriminate on the basis of race, color, creed, etc., but the laws must name very specifically the types of discrimination that vulnerable people are facing, the ones that I call the Black Opticon: over surveillance, discriminatory exclusion and invisibility, and discriminatory predation. You must name those wrongs and then indicate how provisions of the law are going to fight those wrongs. To just say don't discriminate, to me, leaves people of color in the same position they've been in all along, which is to say not well understood and not comprehended. So I actually was argued in favor of race-specific legislation, not just generic, but race-specific. And I'm telling you that, unfortunately, no state has adopted this proposal that we have very race-specific, Black Opticon responsive legislation. So the California laws and the other 19 state laws are weak. In fact, the Virginia law, which I said I've analyzed quite closely, was so weak that the corporate sector loved it. It was like, yay, Google, you know, Facebook, yay, we love it. This is the kind of law we want. But the law had no teeth against industry, and I think that's why it was such a popular kind of a law. So problem with most of the laws, I'd say weak and too generic. Federal regulation, all these amazing statutes are being proposed. And again, I've spent a lot of time, we lawyers have spent a lot of time analyzing these laws. I was on the board until recently of the Electronic Privacy Information Center, and an EPIC staff was spending days analyzing all these laws, going to Capitol Hill, encouraging Congress people to pass these various laws. Same thing with Future Privacy Forum, on whose board I also serve, that the staff really engaged in trying to get Congress to finally pass a comprehensive data protection law. We have no comprehensive data protection laws in the United States, not any. Our electronic communication law is from 1986. 1986. You would think that by now there'd be some major legislation passed, but none of these laws that I cite in the slide have gone anywhere. And so none enacted. Not only that, but the most recent one, the Americans Privacy Rights Act of 2024, which seemed extremely promising. In fact, I would have bet at least $50 it actually would have gotten passed. But it didn't get passed. And not only that, but the remarkable anti-discrimination civil rights language in the statute was stripped out last fall. And then we got Trump, and then we got no law at all. So, okay, dead in the water. And then President Biden issued an executive order. So, presidents in the U.S. can create law by executive order. And Biden used that power to establish a new regime of safe, secure, and trustworthy AI, and that was explicitly designed to help promote the protection of civil rights of privacy. And Trump was elected, and President Trump was inaugurated, and I think it was maybe 2 weeks later he rescinded the Biden executive order and put out his own executive order, which was aimed at promoting global AI dominance of the United States, period. No attention whatsoever to the civil rights of any group of people in the United States or elsewhere. So, concluding thoughts, and I can hardly wait for our conversation. One concluding thought: civil rights discourse, it was a powerful force in the United States in advancing the rights of vulnerable people. It was a very important tool to get us out of apartheid and into a world in which at least there was some opportunity for Black people and other people of color and women and people with disabilities and other protected categories, people to live on par with others. So it's a powerful discourse. But privacy wasn't ever a civil right in the United States, and it's still not a civil right in the United States. To say that privacy is a civil right is at best to make an aspirational statement. You hope that someday the government will enact privacy as a civil right. It's a hope. But so far it's been an unsuccessful and vain hope, because privacy isn't and wasn't a civil right. And the entire concept, I think, in the new presidential regime we're living under right now, the entire concept of privacy as a civil right is under extreme pressure. And why do I say that? Because, as you know, one of the things which President Trump has done is to declare that any discussion of what he calls DEI, diversity and inclusion and equity, any discussion of those things in connection with jobs, education, etc., is off limits. And he has terrorized, I've used that word a lot today, but he's basically frightened schools like my own university, other universities. He's frightened us by threatening to cut off our federal funding if we don't get rid of all of our DEI policies. 6 months ago, if you went to my university's website, you'd see that the School of Medicine had diversity and equity and inclusion policies, and even a person in charge of those things. The medical school, the law school, the business school, the education school, every school, all 12 schools had DEI policies proudly announced on their web page. They had scholarship programs, they had faculty research grants, all this stuff happening. And today, gone, all gone. All gone. Not a single, and already my university has faced an attack from Washington because we allowed a transgender athlete to compete. And so we lost, I think it was $175 million. That was the penalty that Trump imposed because one transgender athlete was allowed to compete. And so, my university has a $1 billion federal research portfolio. And if we were to lose that money, our university would come, it's unthinkable what would happen. And so you understand in some ways why the administrators have to give in and have to yield to some of these pressures from Washington to get rid of DEI. On the other hand, where does that leave the people who needed DEI all along to be treated fairly and to be treated inclusively? So I don't know what's going to happen. But what I think isn't going to happen is that we're not going to find that privacy as a civil right is a very effective discourse in the near future. Maybe in 3 years and 7 months, but not until then. And what I'm already seeing is strategic avoidance of this language of privacy as a civil right. So I think, oh, what a short life this idea had, Came to be 2014, really got announced loudly by Alvaro Bedoya and Daniel Citron and others in 2000. But already, just 5 years later, not even 5 years later, we can't even say the word. Because if we do, punishments will rain down upon us. So I'm not seeing that civil liberties organizations, civil rights organizations are pushing their agenda using this discourse. They've already begun to find other ways to talk about some of the priorities that they believe ought to be a part of the law that we're passing, but they can't utter those words right now. They're not politically acceptable anymore. So strategic avoidance likely moving forward. So that's the story. Is privacy really a civil right? It's not. Thank you.
Thank you so much. So we have around 15 minutes for some questions before the reception upstairs. You're all invited and you will be able to ask more questions to our distinguished guests. So I will invite you to come forward to the mics should you have any questions.
Okay. And I'm going to stand in the middle so I can see people better. Thank you.
Please, the first. Could you open the mic, switch it on the top, just to make sure. Yes, perfect. Thank you.
Can you hear me? Yes.
Yeah,
hi.
it's working.
Thank you so much. That was extremely informative. I'm not very well versed in the context of civil rights, and so I guess my question was twofold. One, if it's a creature of statute, how do you argue for it when there's no statutes? Like you were saying, the literature was influencing the lawmakers to make laws, but if it's a creature of statute, what were they arguing? And the second, I'll just leave it at that. Just first question.
Let me understand better the question.
Yeah.
Okay. So, how do you defend a statute that doesn't? How do you defend a kind of a civil rights statute
How do
in
you
the
argue for a
absence of
civil
any?
right with no statute to back it?
How do you defend? Okay. So it's kind of like a little chicken and egg problem.
Yeah.
Okay. So let's suppose it's 1963, and you believe that African Americans should be able to attend public schools without regard to race. Okay? How do you defend that idea when because you think you need a legal argument to defend the creation of a legal right? Okay. So, but actually, there are many kinds of arguments that can be raised to defend the creation of a new right. Sometimes new rights can be grounded in existing law, existing, say, charter law or constitutional law, like a right to abortion. Doesn't exist, could be based on charter law or basic law in Germany or constitutional law in the United States in the past. So sometimes you can defend a statutory change by referring to a fundamental law, right or law or common law right. But you don't need that. All you need is moral suasion, right? I mean, sometimes you can just base the creation of a new right on the fact that the public has come to see, come to recognize a need for that right. It's just based on public consensus, right? Sometimes you can, I call that downward-looking argument, right? That the people have now come to a different consensus about the way the world should be ordered. And so we're going to enshrine that consensus in a new statute. Upward-looking thinking, it's where religion or natural law or sort of ideals of right and wrong could actually be the basis of creating a new legal right. And then sometimes just forward-looking public policy, whether it's economic policy or some other social policy, those policy arguments can ground a new right. You don't need to have what I call the backward-looking positive law basis for a new positive law. New positive law can come from old positive law, from public opinion, from ideals, moral ideals, or from policy arguments. That's how you get a new law. And if all those things converge, maybe you can convince your congressperson. The sad thing, though, is that sometimes all those things do converge, but you have stubborn lawmakers who still don't want to vote your way.
Yeah, thank you. I guess my other question was, why not leave it to the courts? Like, why not argue for a judicial interpretation of current law as opposed to a brand new law that doesn't have any foundation?
Well, remember how I told the story, how when we tried to use in the 19th century, when the first civil rights laws were enacted, the courts did not side with civil rights. He sided with the racist. And so sometimes you can't rely upon the court, and that in those situations you need the Congress, the lawmakers to act, and then the courts say, okay, well, since the lawmakers acted, and now we think differently about the law. Also, sometimes the law changes when the law stays the same. So the same provisions in the Constitution that were deemed in the 19th century to not allow the government to require anti-discrimination by private people, those same provisions looked through a different lens in 1964. The courts upheld the laws. The same Constitution, different judges making different interpretation 120 years later. Yeah.
Thank you so much.
Thank you.
Thank you so much. Jane.
Hi, Jane.
Hi. Thank you so much. That was a tour de force, as always. My question is, sort of as somebody who's come at this from a feminist scholarship point of view, where it's the idea of non-discrimination has generally been anchored for me in the idea of equality.
Yes.
And substantive equality in particular. And it's only in very recent years that I've started to see how these two, privacy and equality, are so inexorably tied. Mm-hmm. Now, I just wonder from a strategic point of view, why base an argument about collective rights to non-discrimination in a concept like privacy, which is so traditionally thought of as individual and kind of negative, where why that would become the sort of right of choice, if you will.
Yeah, Professor Bailey, thank you for that great question. And in fact, I think that one of the reasons why during the civil rights movement there wasn't a sense that privacy problems are civil rights problems is that the focus was on collective well-being, collective efforts to ensure collective well-being, not on making this person or that person less visible or this person or that person less surveilled. And I think that's probably why it didn't catch fire then. But I think once we had a platform of civil rights that had been successfully achieved, then folks in more recent times thought, okay, well, civil rights discourse worked back then, maybe it'll work now. But I think that's ignoring the reasons why it didn't work before, and maybe it shouldn't work. It shouldn't or won't work today. I think that we can see privacy rights as having both individual and collective goods attached to them. But I know, as I know you know, from the feminist debates, that that's an ongoing argument and contentious battle.
Yeah, thanks for that. Yeah, it's always one of those things where you know that sort of some of the flat conceptions of privacy that have been out there are inadequate and shouldn't necessarily capture the imagination.
Yeah.
But they have to some extent, especially in law. And so it's that, like, how long am I going to bang my head against the wall before I try something else? So that's a.
And you may notice that I didn't include myself as among the people who originated the idea of privacy as a civil right, even though if you go back and look at my first book, which is Uneasy Access: Privacy for Women in a Free Society, I did argue that Title II and Title VII issues were at stake in sexual harassment and stalking, the kind of things that Danielle Citron writes about today. So I think I saw that civil rights were connected to privacy, but I didn't make that final, I didn't staple them together. It's like they're here, but I didn't staple them together tightly. And I think it's because I wasn't even thinking that as a general matter, we should view freedom from interference with our information or our bodies, et cetera, as civil rights issues. But I knew that civil rights law could be, I sense that, and I talk about it a little tiny bit, but I don't really ever develop it. Danielle developed it. Yeah?
Thank you.
Thanks. Yeah.
Thank you so much. So,
hi, my name is John Anderson. I work for one of the large federal government unions in Ottawa. PIPS, we have about 75,000 members. One of the issues we're really worried about right now is the question of monitoring by the employer.
Yeah.
The federal government has already been caught monitoring about 13 different agencies and departments through various methods, even using a robot to roam around the office and monitor people. And
at least you know it's happening, right? When it's a robot.
Yeah, right. But most of it is secret. They haven't told anybody they're doing that. And I know what's happening in Washington, and I sympathize greatly with those who are hit by everything, the terrible things that are happening there right now. But I was wondering if in any states, is there any kind of protection that's being offered to employees by state legislation around protecting them in terms of privacy and monitoring and some kind of protection from artificial intelligence? I mean, there's a lot of American states. You'd think that some of them might have some progressive legislation there.
Well, I don't think so, because the pervasive view in the U.S. is that the employer owns the computers and the telephones that their employees utilize in the office, and so therefore monitoring of those employer-owned facilities in the interest of determining efficiency and compliance with workplace rules is completely appropriate. It gets more complicated when people are working at home, and the monitoring is that sort of not. It's the physical space in which the monitoring is happening is arguably not the workplace, but the home, and so now this is complicated. Our thinking about the rights of employees, but monitoring the keystrokes of employees, that's happening in the U.S. Other kinds of surveillance are happening as well, and the pervasive view is that the employer is entitled to an efficient, compliant workforce, and therefore they are entitled to use technology in order to ensure an efficient and compliant workforce, and there's not much opposition, from that has been powerful enough to get the courts to think differently, or the lawmakers to think differently about those issues. So I'm sorry I can't give you some weapons to use here in Canada, because I think that we're in the same boat that you're in, the same boat.
please give a round of applause to Professor Hall and to Danke.
Thank you. Thank you.